We'll now proceed to rules relating to company names. And this is guided by Cap 499 laws of Kenya. Cap 499 is the registration of business names. We're looking at the revised edition. And it will be a guiding factor in how you register a business name. You can look at it later on. So we will read this with the Companies Act. Remember, what we are doing is the registration of a company. So as much as we will use the registration of business names, our key law is the Companies Act. So what are the rules regarding the name of the company? A company cannot adopt a name by which another company is registered. If by mistake you choose a name that is of an existing company or closely resembles it, the name must be changed. Also, if the name of a company closely resembles the name of a previous company, the public may be misled and may be defrauded. And in such a case, the court will direct the change of name of the company. We go to the Companies Act, Section 19, whereby Section 19 itself provides that, and these are the provisions with respect to names of companies. And the registrar may, Section 19(1), reserve a name pending registration. The reservation is for a period of 30 days, but not exceeding 60 days. So number 2 is what we are concerned with. No name shall be preserved, and no company that shall be registered by a name which consists of abbreviations, initials, or by a name which of the opinion of the registrar is undesirable. What do we mean by undesirable? What we have said, if it's too much like the name of an existing company, if it's misleading. For example, if the name of a company likely to have small resources suggests that it's going to trade on a greater scale over a wild field. Say case in point, my company, I have formed a company. I am yet to expand my business, but the name I have chosen misleads you into thinking I am a global company. The registrar may reject that name. If I'm to use my name and insist on adding the word global, yet on the face of it, I am yet to break the barriers of Nairobi, for example, the company name may be rejected because it will mislead the public into thinking that you are doing business way over and beyond because of your name. Again, if the name suggests some connection with the crown or members of the royal family or royal patronage, and these will include names containing words such as royal, king, queen, princess, and crown. Also, if the name suggests the connection with the government, department, or any municipality or other local authority, or anybody incorporated with the government, or any part of the Commonwealth or any foreign country. For instance, I cannot name my company and add names of Tanzania, Uganda, which would mislead the public into thinking I am connected with their government or I am acting on behalf of their government. The registrar will reject such a name because the public must be protected. from dealing with fraudsters. Also, if the name you choose contains the words British, unless the undertaking is British controlled and such, it will also be rejected if it includes a surname which is not that of a proposed director, unless the circumstances justify the inclusion. You cannot pick a name from the blue because you assume it will bring you businesses. Case in point, picking the name of a well-known politician or a well-known businessman and adding it to your name with the intention of misleading the public that you are in direct business with this individual or this individual supports your business, yet in fact, he has no known knowledge of your business, whether it exists, what it does. So such a name will be rejected because again, it seeks to deceive the public of your connections, of the work you're doing, of the outreach your business can reach. It will also be rejected if it includes words which might be trademarks, unless a trademark clearance has been obtained. We talk of trademarks, Coca-Cola, Puma, these ones that they're registered trademarks, they're well known. So in forming your business name, you're not allowed to use those trademarks because the public purchases goods based on that. When you see that symbol and automatically you assume you're purchasing, whether or not it is that. So your name will be rejected if it is seen that you want to associate with that trademark, but you are not part of that business. You have not been allowed by law to use that name. So it will be rejected. So when we name a company, what else is important? So the name and address of the registered office of every company must be painted or fixed on the outside of its business premises in a conspicuous position and letters that are easily legible in one or more of the languages used in the locality. So the words limited and private limited are parts of the names of public and private companies and must be added at the end of the name of the company. So where you have a seal, the name and address of the registered office must be visible. And it must be mentioned in all business letters, the bills, all notices, and other documents. So where you're doing advertisements, they may not be mentioned. So if you want to change your business name, the registration of business names provides that if a company that was registered by a business name under which the registration should have been refused, or the change of ownership occurs as a result of which a company carrying on a business which on application for registration under the Act ought to have been refused, the registrar shall by notice in writing require the company to change such a business name within a specified time. So what do we mean by this? Where it is found that your company was registered and it should not have been registered, that business name, you are required to change it. Chapter 9 of this talks about Subject to subsection 2 of section 17, whenever a change is made or occurs in the following particulars in respect of any firm, individual or corporation, that is to say the business name, the address of the principal or any other place of business, the nature of the business and the names of the partners, such firm, individual or corporation shall within 28 days after such change send by registered post or deliver it in writing in the prescribed form, specifying the nature and date of the change, signed and where necessarily verified. Provided that we talk about the notice, so section 17 of the registration of business names is where we were reading from, where the restriction on registration of certain business names. So the registrar may refuse to register or even change a business name if whereby your first business name was refused or you should not have been registered. You go ahead and again change it, but you include these words. The public as to the nationality, race, or religion of the persons to whom the business is wholly or mainly owned, where it includes these words, presidential, government, municipal, that suggests that the business enjoys the patronage of the president or imports any connection with the government or with any municipality or other local authority. You're not allowed to use currently in Kenya names like the county government of Kiambu, county government of Kisumu, county government of Mombasa in your business name. It will mislead the public to imagine that you enjoy business with that county government or you are at an advantage with the county government. You are also not allowed to include the word cooperative or its equivalent in any other language or any abbreviation thereof. We had talked about the differences between a cooperative and a company. And section 17 restricts you from your business name in using the word cooperative. You're also not allowed to use the words Old Law Court Mombasa, National Monument, Lamu Fort. Any of these names are not available for use as a business name. Part D provides that any name which is identical with or is similar to that of a business or corporation existing or is already registered under that act or under the Companies Act, and as we have said, it will mislead the public, you're not allowed. It also gives the registrar discretion. If the registrar feels that this particular name that you want to register is undesirable, he may refuse your application for a business name. You must also remember the discretion of the registrar is also applicable, whereby if your business name has been registered and you are told that it should not have been registered and you continue carrying on with it, the registrar has the discretion to cancel that business name and you will apply afresh, taking into consideration all the documents that we have set aside to be provided for. So what is the significance of registration? You must remember that no company or association or partnership shall trade unless and until it is registered. We have talked about the restriction on the registration of certain businesses. We talked about the Act provided about the reservation of the name, whereby we said for 30 but not 60 days. And these statutory provisions, they intended to confer on the company legal monopoly of its name. Because a company lacks physical attributes which could assist its customers to differentiate it from another company, a company can only rely on its name, and that as such is the ultimate protection against what might constitute unfair instances of passing off. And this act, the Registration of Business Name, as well as the Companies Act, they avoid a situation where two or more companies use one name with the resultant problem of identifying the company that is a contracting party. Section 5(1)(a) provides that the word limited must be the last word of the name of a company to be limited by shares or guarantee. So we talk of Durham Fancy Goods versus Michael Jackson Fancy Goods Limited. Donaldson J. stated, the word limited is included in a company's name by way of description. It's not an identification. Accordingly, a generally accepted abbreviation will serve this purpose as well as the word in full. The rest of the name by contrast, serves as a means of identification. So what do we mean? In the registration of a business name, using LTD as an abbreviation for limited in full, it does not seek to identify your company. You cannot be held liable if another company chooses your name and instead of abbreviation uses it in full. But the company name is the identification. So for this, Durham Fancy Goods Limited in full and Fancy Goods LTD, the LTD and the limited are not, there is not much weight put in the name limited, because limited, as you have spoken before, you have discussed, is whether it's limited by shares or by guarantee. The name itself, Durham Fancy Goods, that is what identifies you and what you are selling, what you are transacting in. And that is what will be considered should another company come and use your name, but instead abbreviates. When do we have the powers to dispense with the word limited? While Section 5 provides that the last word of the name of a limited company must be limited, an existing registered company may obtain a license to make by special resolution a change in its name so as to omit the word limited. And this can only be done by providing that the company is formed to promote clarity and is prohibited from paying dividends to its members. So we had talked about the change of name. It can be voluntary or it can be compulsory. So Section 20 provides that by special resolution, Section 20 of the Companies Act, not the Registration of Business Names, a company may by special resolution and with the approval of the registrar change its name. Again, we will go back to their names, and if under Section 22, when it was inadvertently registered by a name which is too like the name of another company, in this case, 2A, no resolution will be needed. And no special resolution will be needed, but by ordinary resolution. And although this section does not make it mandatory for the company to change its name, it's advisable once you become aware that your company name is similar to that of an existing company, for you to be able to trade with that. We have said a company's name is what defines it. It's what sets it apart because it has no physical attributes. You see, for an individual, you can be described by your height, your complexion, and other things. But for a company, the lack of its physical attributes means the name is very important in identifying itself. It is what sets it apart from other companies that are in existence. So once you find that the company you intended to form shares a name with another company, make steps to ensure that you change your name. So that is for the voluntary. We have the compulsory. Again, section 22, we rely on that, where the registration within 6 months, the registrar will direct a change. And the notice we had talked about, you enter the new name in place of the former name. The registrar will issue a new certificate with a change of name, and this name will be published in the Kenya Gazette. You must remember that the change of name will not affect any of its rights or obligations or render defective any legal proceedings by or against it, and any such proceedings may be continued or commenced against it by its new name. We talk about the publication of a name, and which is what we were saying about the company making it visible and endorsing it in its seal and its place of business, and it must be visible. That where you're conducting your place of business, it can be identified. You affix a sign showing that your business is transacting here. In the publication of true names, section 23(1) of the Registration of Business, in the Registration of Business Names Act, provides that a company using a business name distinct from its corporate name must disclose its corporate name in all trade circulars and in businesses or in which the business name appears. Mwangi, you had talked about the memorandum of association, and your question was whether the memorandum can be altered. And the law provides that every clause of the memorandum may be altered except the registered office clause, which constitutes Kenya the company's domicile. Section 25 allows a company to alter clauses that are included in its memorandum, but could lawfully have been contained in the articles. And such clauses can be altered by a special resolution except where the memorandum itself provides or prohibits the alteration of any or all of the said conditions. So holders of 15% of the issued shares have 30 days to apply to the court to change the alteration. And in the event of such application, the alteration shall not have effect in as far as it's the law provides. So as we had discussed, the memorandum is the constitution of the company. In itself, it provides all it needs in order to be the changing of the alteration of anything, the procedures are provided. So we look at the articles of association, and these are documents which contains the rules, the regulations, and the bylaws regarding the internal management of the company. So these articles must not violate any provision of the memorandum or any provision of the Companies Act. So the rules laid down in the articles must be read subject to the rules contained in the memorandum. The articles of association are secondary to the memorandum of association, and they cannot be against the law. They can also not be against the constitution of the company. So what are the rules contained in the articles of association? For a private company, the articles contain the restrictive features peculiar to private companies. That is, the limitation of members to 50. It also contains the restriction of the transfers of shares and the prohibition of invitation to the public for the purchase of shares and debentures. We must understand that whereas the memorandum forms the company's intention to trade, and in it what the company does and where the company is located, the articles go ahead and provide what cannot be done in respect of private companies. For example, the number of members is limited, the transfers of shares is limited, and the invitation of the public. What we mean is that the articles are the ones that restrict a private company from inviting the public to purchase shares. Both the articles and the memorandum of association are listed, they are published. So in case of a company limited by guarantee, the articles state the number of members with which the company is to be registered. In the case of an unlimited company, the articles state the number of members. If the company has a share capital, the amount of such share capital. So the articles of association go into the nitty-gritties. The memorandum provides the umbrella of the company. The articles are what is the day-to-day running of that company. So Section 12 provides that the articles must be in English, they must be printed, they must be divided into paragraphs numbered consecutively, they must also be dated, and they must be signed by each subscriber to the memorandum of association in the presence of at least one witness who shall attest the signature and add to his occupation and postal address. These documents, once taken to the registrar of companies, you must remember they are what the public will rely on. We have said that a company does not have a physical face. So what defines it? What enables an individual to identify it are the documents that are presented to the registrar of companies. And the reason why each person signing has a witness to that signature, you cannot again go back and say you did not sign. You see, ignorance of the law is not a defense. And once a person attests to your signature, effectively, you have proven and shown that you have sound mind when you are signing, when you are assenting to your signature being provided. And for every person that goes through these documents that you have provided, once a company is formed, will be able to attest that these documents, you read the documents, you agreed with the documents, and you are able to present them such that they represent your company. So what are the contents of articles? They have the preliminary contract, they have the number and the value of shares, they have the share certificate, they also contain the lien on the members' shares, they contain the alteration of capital, they provide for general meetings, they also provide for the directors and their remuneration, for the dividends and reserves, and accounts and audit. Most importantly, it's the shares that provide for the winding up of a company. So the articles of association are commercial documents, and they must be construed so as to give the company a reasonable business efficacy and make them workable. They are what the business is up to. You see, we have said they provide the winding up solutions. They also provide what directors will be paid and dividends, if any. They also provide for the accounts and the audit. It's in the articles of association that we find out when will the company be audited, how will they present their books of accounts, who will do their books of accounts. So what are the legal effects of articles? Section 22 provides that the memorandum and articles shall, when registered, bind the company and the members thereof to the same extent as if they respectively had been signed and sealed by each member and contained covenants on the part of each member to observe all the provisions of the memorandum and articles. So the English courts have interpreted these as follows. It's a statutory contract which binds members to the company and binds the company to the members. Therefore, a company may sue a member to restrain an immediate breach of the articles. This was in Hickman versus Kent, in which the company obtained an injunction restraining Hickman from going to court in breach of the articles which provided for arbitration proceedings. So the articles provide for what happens when a contract is breached. If they provide for arbitration, as many do, you cannot then go ahead and take them to court before having gone through arbitration. Articles provide the day-to-day. And since the company is in existence, it can sue you, and you can also sue it. They bind the members and the members to the company. But the members are bound to the company and the company bound to the members only in their capacity as members. So in LA versus Positive Life Assurance, LA failed in his contention that the company had committed a breach of contract in the articles, which appointed him as the company's lawyer for life, because he was suing as a lawyer but not a member. If LA had gone to court as a member, could have been heard. But where you are a third party, you see a lawyer is a third party in that company. He cannot, the articles are not bound to third parties. They are bound to members and members bound to them. In BT versus EFBT Limited and another, the company failed to restrain Mrs. Beatty from suing in an alleged breach of the articles, which again provided for arbitration. The court explained that Mrs. Beatty was suing as a director, not a member. She was therefore not bound by the arbitration clause, which required members to refer disputes between them and the company to arbitration. So in this other case, where you sue as a director is appointed by the company. A director is not a member. So where a director is not bound to the company by the articles of association, but a member is. So a member can sue, and a member cannot sue. They will only rely on arbitration, but a director can. So members are also bound by the preemption clauses, which requires members intending to sell their shares to offer them first to existing members who are given a right to buy their shares in preference to third parties. So the articles of association also provide that if you wish to exit, the first people you offer to sell the shares to is the members of that company before giving them to third parties. The articles bind you and the company to each other. We have the alteration of articles, and it is provided for in section 13.1. By special resolution, you can add or alter, but it shall be valid if the law is followed. So Section 13 again provides that alteration is subject to the conditions contained in the company's memorandum of association. So any alteration must be as per the memorandum that sets out the objects, the clauses, the reasons for existence. You cannot alter against the memorandum of association. Again, the alteration is as per the law, is as per the provisions of the Companies Act. So where you seek to alter anything that contravenes the Companies Act, that alteration is null and void. Section 24 provides that no member shall be bound by an alteration made in the articles after the date on which he became a member. And the alteration requires for him, in as so far as the alteration requires him to take or subscribe more shares than the numbers held by him at the date on which the alteration is made, or it increases his liability, you note that the alteration is valid, but it does not bind members who have not agreed in writing to be bound by it. So whatever alteration is made in the articles, especially when it comes to increasing liability or increasing shares, as long as the members have not agreed in writing, they cannot be bound by it. The alteration is legal, yes, but the people it binds are those who agree in writing. In Allen versus Gold Reefs of West Africa, Lindley stated that the powers in the alteration of the articles, they must be only exercised subject to the general principles of law and equity, which means that not only are they exercised in law, but they must be of benefit. They must be beneficial to the members. So these alterations that are being made, they cannot be made whereby they seek to harm the members of the company. Any alteration that is made to the articles must be beneficial to these members. So for any proposed alteration to be effective, it must be bona fide and the benefit of the company as a whole. So we have said Bottom versus Kisho Lease and Company, in which the alteration was held to be for the benefit of the company, where in this case, the articles were changed to allow for the compulsory purchase of shares of any shareholder who was competing with the company. So one shareholder was competing with the company and challenged the alteration. And he used the previous case where a change for compulsory was held invalid as not being bona fide. But the Court of Appeal held that the article alteration was valid and for the benefit. And if that is why the alteration is made, you see, in this company, they wanted, before you sell off to a competitor, give the members a chance to buy off these shares from you. You see, it's for the benefit of the company. You are not diluting the company and you're not exposing the company to competitors. So what is the relationship between the memorandum and articles of association? Again, we refer to Ashbury Railways Carriage and Reach. The memorandum, as it were, the area beyond which the company, actions of the company cannot go. Inside the area, the shareholders may make such regulations for their own government as they think fit. So what does this mean? The memorandum of association governs the relationship between the company and outsiders. The articles governs the relationship between the shareholders and directors of the company. We have spoken about why we need the articles of association. why we amend them for the benefit of the company. The articles describe the relationship with the other shareholders, the members of that company. You cannot alter if it's not for the benefit of the company. You give the shareholders, the members, the chance to purchase. The memorandum of association provides the reason as to why the company is in existence. It's the constitution of the company. It's the charter upon which the company is founded. So both are public documents, as we have said. They're available for inspection by anybody at the office of the Registrar of Companies. And anybody dealing with that company, and which is why we said the documents provided for, the list of the directors, the lists we talked about, the forms 180, 190, they're available for inspection. And the assumption is before someone engages with you, they're presumed to have read and gone through your documents. We must also remember the memorandum being the charter of the company, any article contrary to what the memorandum holds is invalid. So what are the legal effects of the articles? The memorandum and articles shall, when registered, bind the company and members to the same extent as if they respectively had been signed by the company and by each member.